Okay, well, good morning and welcome to you all. Thank you for joining our webinar today, looking at insolvency in the construction industry, what to do and what to be aware of. This webinar will be recorded, so for those that aren't able to watch it live, then you can watch it after the event at your leisure. My name is Paul Gibbons and I am the founding director and chief executive of Decipher Consulting. This webinar today, as I say, is to be based on insolvency in the construction industry. And some research from Statista Research Department published on the 6th of April of this year suggested that insolvencies in the construction sector of Great Britain soared in 2022 to over 4,332 cases. This was up from 2,733 cases in 21 and up again from 2,175 cases in 2020. There's some further research from the Red Flag Alert, which was published in January 23, suggests that the UK construction sector is facing a challenging year this year with over 6,000 expected company insolvencies, with 300 million in debt, and this is expected to increase to 1 billion in 2024. And so with unpaid bills putting pressure on staffing and supply chain with a legacy from COVID, alongside current interest and inflation rate pressures, things can only get worse, but hopefully they will get better in due time. We have got over 125 people registered for this event today. So from that alone, it suggests it's a current hot topic. The webinar will consist of 3 presentations consisting of David Banks from Hill Dickinson. He will look at the legal aspects. Colin Wilson from Opus. Colin will look at the insolvency through the lens of the practitioner. And Bill Bordill will look at the quantum aspects from Decipher Consulting. At the end of the session, there will be a panel discussion that I will facilitate. So if you would like to ask any questions, please put them in the chat or the Q&A, and we'll hopefully have time to deal with those matters at the end. So without further ado, I'll introduce the speakers. So David Banks. David has been a legal director within the National Construction and Engineering team at Hill Dickinson since 2021. And he's worked his way up from associate in 2017. David now leads the Manchester arm of the construction team. David prides himself on being a versatile lawyer, acting in both transactional and contentious matters across the industry for developers, contractors, subcontractors, consultants, and funders. And he specialises in dispute avoidance and resolution regarding payment issues, defects, and general contract management. He has a keen interest in development finance matters, as well as adjudication enforcement, and in particular adjudication enforcement when a party is insolvent. So a key person to have on today's chat. I'm also joined by Colin Wilson. Colin is a founding member of Opus Restructuring, which was established 10 years ago. He has over 25 years of experience in the restructuring and insolvency sector, and his core discipline is insolvency, but he specialises in corporate recovery, including administration, bankruptcy, compulsory liquidation. At Opus, his focus is to deliver partner-driven services to small and medium-sized enterprises, and the group offers support with both financial and operational challenges. So again, welcome, Colin, to this event today, and thank you for joining us. And finally, we've got Bill Bordill, who's a director of Decipher Consulting. He has over 35 years of experience within the construction and engineering industry, gained with consultants, main contractor, and subcontractors. Bill is a chartered quantity surveyor and now practices predominantly in the area of dispute resolution as either adjudicator, expert determiner, quantum expert, or party representative. So as you can see, we've got a good fine panel there of knowledge, and we will commence now without further ado with David delivering his first presentation. So David, over to you, please. Thank you.
Thank you very much, Paul. I'm just going to hopefully share my screen, which works well enough in practice, but let's see how the real thing goes. We are. Okay. So thank you again, Paul, for your warm words just there. And I'd like to extend that thanks to Decipher generally, along with Stuart and Caris of Limeslade for facilitating today's event. As Paul mentioned, I'm David Banks from the Manchester branch of Hill Dickinson. I work across contentious and non-contentious matters, and I feel that gives me a useful position to provide an insight as to how insolvency provisions are drafted into construction contracts, and also what happens as and when things go wrong, as they often tend to. Insolvency is obviously a very wide topic, so I'm going to jump around a little bit today between a few market trends, which I've got to say, Paul just stolen my thunder a little bit there with some of the stats he's provided, so hopefully they align with what Paul said. Some insolvency warning signs, some contractual options in construction agreements, and then also finally to look at the link between insolvency and adjudication. I'm going to try to strike a balance between looking at matters from the perspective of both the insolvent company as well as that of those in contract with the said company.
David, sorry, yeah, your slides are moving now, David. Thank you.
All right, great. So, starting with some market trends. Now, each morning I get an update from the Construction Inquirer via email at about 9 o'clock each morning. So I'll be getting that just now. And unfortunately, that often talks of further financial fatalities. The bottom three companies on that list on my slide just there, Clement Dickens, ME and Henley, have all fallen to insolvency processes over the course of the past week or so. Tolerant was obviously a big one earlier this year. It doesn't make for happy reading, obviously, but it's important to know what's going on in the industry and also to remain realistic about it, in my view. Some possible reasons for that, and I describe them on my slide as the perfect storm. I think it's safe to say a few things have happened over the past few years, which are relatively well rehearsed and set out on that slide. In an industry that's already susceptible to insolvency, that's especially the case, bearing in mind those factors. So, as Paul mentioned, the red flag alert, which is the Begbie's insolvency tool, provides us with more good news, unfortunately, which is that it anticipates 6,000 construction insolvencies in 2023, and so that situation is certainly not a healthy outlook. I've also got some further analysis from Professor Noble Francis, who is the economics director at the CPA, the Construction Products Association, and he says that he expects that 291 construction firms in the UK went out of business in January 2023. The positive is that that's 19.4% lower than the previous month and 8.5% lower than a year ago, according to the latest data from the government's insolvency service. So taking that as a positive, there has been something of a decline. It's also important to note, however, that that's only one data point, and insolvencies often fall during the winter period, as I'm sure Colin will testify to. So it's too early to see whether that's the start of a downward trend. Professor Francis also says that in the year to January 2023, and I think again Paul mentioned this stat, 4,135 construction firms went out of business, which is slightly lower than the 4,162 that fell in the year to December, which coincidentally was the highest number of construction insolvencies since the financial crisis over 10 years ago. 58% of the firms that went out of business were specialist contractors, considered likely to be smaller firms on fixed price contracts signed before price rises or the significant price rises in materials costs. To add to that, there was also the rising labour costs, rising PI insurance market, and amongst other external factors. January 2023 saw the number of specialist contractors that went under fall by 22.2% compared with the previous month, December, and that was 13.6% lower than the previous year. Main building contractors accounted for 37% of those insolvencies in January, and that was 17.3% lower than in the previous December, but 4.8% higher than the previous year. And finally, on stats, only 5% of the firms that went out of business were civils firms, compared with 6% in the previous month, which would suggest that civils firms are less impacted and tend to be less impacted in any event due to strong infrastructure activity, essentially. I think that probably also attributed to public sector and regulated sector clients likely to have more of an understanding of cost inflation issues and being less stringent, essentially, on enforcing fixed price contracts. So I'm going to move on to some practical points now, leaving the stats aside, and what I think the issues are to look out for in terms of possible indicators of financial difficulties. And the slide on screen at the moment gives some examples of those. So the things I'd look for, things such as low productivity. If you've got a supplier who is struggling to secure labour or materials, a failure to pay its own suppliers. Company's house is something that can be accessed by anyone, and that can be monitored in terms of late filing of accounts and extended reporting periods. And then there's the more obvious issues, such as court proceedings being commenced by potential creditors. Again, if you sign up to CE file, which is the court's filing system, it's possible to check that for cases involving said supplier, and it's perhaps sensible to do that at the outset of placing an order. I think the last point I've mentioned there, the low pricing and margin issue, was something I added quite late following some advice I gave quite recently, where I was approached by a new contractor client who'd allowed a fairly slim margin of 4 to 5% profit on a relatively low price job. And that was on a fixed price contract, in which the contractor had taken on all the risk. And I should say that was done before they approached me to have a look at the contract. And you can probably guess what followed. The contractor hadn't anticipated there being issues with ground conditions, and approached me asking if he was able to vary the contract at that point. Of course, the answer to that was he was unable to do so, unfortunately. So I think that the message there is that risk allocation is important from both perspectives, as it will ultimately drive profit on the contract. The message is to check contracts, check pricing, and from an employer's perspective, also to check whether a supplier can actually carry that risk. Sorry, if it's your organisation that's trying to pass on that risk. So, notwithstanding what I said in relation to the previous slide, insolvency in the industry remains inevitable. So the current slide contains perhaps some tips as to what parties can actually do to avoid an insolvency process, or to avoid falling foul of the issues that it causes. I think as an initial step, from both perspectives, really, I would suggest that it's preferable to begin with a constructive dialogue with a view to securing a form of commitment in relation to any outstanding debt. That might be by way of a form of security, perhaps a repayment plan on the basis that something over a long period of time is certainly better than pennies in the pound. Is there potential for a new work opportunity to be referred, or even a guarantee from a director or a group company? My suggestion would be that be followed up in writing, and a record kept of any such communications as well. Second point, I think it's important to monitor credit throughout the course of a project, and not just at due diligence stage, and certainly not to extend credit where there's no obligation to do so. Working on the basis that those first two steps haven't worked, I think it's important to consider seeking advice in relation to the issue that you may be having. That serves the purpose of improving a negotiation position on repayment, or also maybe potentially looking at recovery via litigation. I've also mentioned enforcement on my slide. I think revisiting your contractual options and considering whether you have existing security, which I'll move on to in more detail in the next slide, but that's also an important factor to bear in mind. I think lastly, consider adjudication as a means of a potentially faster recovery. Adjudication obviously being largely specific to the construction industry and with cash flow in mind. Again, adjudication is something I'm going to look at later on in terms of its specific relationship with insolvency, but it's again an important and a crucial means of recovery in the industry. An important factor, obviously, to bear in mind with those last 2 points is one of commerciality, and I think it's important to keep in mind whether the insolvent company actually has the assets to justify actually spending the money and getting to that point. So turning to the 3 issues on the slide in particular now, which I'm going to work through in turn, as they're all obviously key to today's wider topic. So I'm going to look at payment, termination, and then security. So starting with payment, the usual rule, regardless of whether or not a company is engaged in the insolvency process, is that if there is a notified sum following a valid application for payment in a construction contract, then that sum becomes payable. That is, unless, of course, there's a valid payment notice or a pay less notice for a lesser amount. Important to be mindful of pay when paid clauses, which fall foul of the Construction Act and will not, certainly not always, if they are assessed to be a pay when paid clause, be enforced by the courts. I'll touch upon that issue further with some case law on the next slide. In terms of whether you still need a pay less notice if you're dealing with an insolvent party, I think my advice would be it's always important to be cautious in that respect, and I'd always therefore advocate issuing a notice to prevent the possibility of a costly smash and grab adjudication as from the perspective of a paying party at least. So as promised, some case law. The William Hare and Shepherd construction case was actually a 2010 case, but it remains very relevant to today's topic. The case concerned a pay when paid clause, which I mentioned on my previous slide, and that clause sought to enable Shepherd to withhold payment from its subcontractors in the event of the insolvency of Trinity Wakefield, who were Shepherd's employer at the time. Hare were one of the subcontractors on that in that case, I should mention. So an issue arose because the contractual definition of insolvency in that case was by way of reference to the insolvency procedures in the Insolvency Act of 1986, which failed to take account of the amendments to the administration regime, which of course enabled a company to enter insolvency other than via a court order. And that's exactly what happened here. Trinity entered administration without a court order, and the court was asked whether Shepherd had to pay its subbies. Shepherd sought to argue that the administration of Trinity triggered the pay when paid clause. The Court of Appeal in that matter found that the clause was ineffective, as it's reference to the making of an administration order, and did not cover out of court administration. The outcome of that matter was that Shepherd had to pay Hare just less than £1 million in fees. The wider implication of that matter, of course, is that there would have been other subcontractors of Shepherd, no doubt on similar terms, and these other supply chain members, and essentially Shepherd would have had to cough up in those circumstances as well. Turning to suspension rights, which are also important and have a role to play in insolvency scenarios. So what happens if you're not paid as a contractor? And the answer to that is quite simply that you're entitled to suspend your works by way of the Construction Act if you're able to establish that there's a notified sum payable and it hasn't been paid by the paying party. The various forms of standard form contracts mentioned on my slide there, JCT, FIDIC, and NEC, all also allow the employer to suspend works in certain scenarios. And this is one issue to be aware of, I think, that of suspension, even if it's only used sparingly, that in the exercising of a statutory or contractual right of suspension of works with a view to potentially waiting out inflation or costs or supply chain disruption, it's essentially an option as a stopgap measure, though I appreciate that the time is always critical on projects. So just continuing with contractual and statutory suspension rights. My view is that the right to suspend can provide an adequate mechanism for assisting with it as a temporary form of relief, but it may not be of assistance in dealing with the medium to long term economic issues that arise from insolvency. I think it's necessary to establish a careful balancing exercise in terms of what what's needed to be undertaken if a suspension actually offers a true commercial benefit overall. And so I think it's important to be aware of the right to suspend in the event that an insolvency is encountered. I think above all, it lines up the right to terminate the contract, which may unfortunately become inevitable. Again, I'll move on to that shortly. So both the JCT and the NEC give the contractual right to terminate following insolvency, and the slide there sets out how those two forms of contract differ slightly. So the JCT gives a right to terminate for inadequate performance, subject to notice having been provided, and that's not necessarily insolvency in itself, but if you've got an insolvent party, then the likelihood is that they're not going to be performing to the required standard, shall I say. And there's of course the fact as well that insolvency of either party suspends the contractor's obligations to perform. That's different to termination, though you should note. Some practical points there as well. Following termination for contractor insolvency is to consider things like security over site materials and removal, or in some cases not, of the site establishment, potential assignment of supply contracts. And a further practical issue to certainly be aware of is that as an employer dealing with an insolvent party, it's important to finalise your account following making good, in order that any money due can be recovered potentially from by way of contacting the insolvency practitioner. So the NEC position differs slightly. Again, there's a right to terminate for inadequate performance, subject to the project manager confirming that default is ongoing after the issuing of the relevant notices. Each party is able to notify the other and the project manager, who then issues the termination certificate. And as with the previous slide, some practical issues arising following termination for contractor insolvency is those of site materials and removal of equipment, and again, potentially consider the assignment of supply contracts. And again, there's an accounting process to be carried out at the end of that process in order that any recoveries can be made.
Sorry, David. Sorry, David. Your slide isn't moving.
Yep.
It's moving now. It's on the bond now. It's on bond.
All right, I say yes. Okay. Thanks, Paul.
Thanks. Thank you.
So looking at some of the options by way of security against insolvency. So I mentioned a bond on my slide just there, which isn't overly helpful given the move away from on-demand bonds and the cost of the same. There's also the need to ascertain fees, which is or to ascertain money's due, which isn't always possible at the point of insolvency, and also there's inevitably some delay, which certainly isn't helpful in terms of not only cash flow but also in terms of the crucial timing of the project. Also worth considering, I think, whether there is the option of having the relevant contract novated to a group company, if that is an option. Of course, that of course requires the insolvency to be the insolvent company to be part of a wider group. But this was an issue that a colleague of mine had recently, in which some of there was an agreement with the IP that those contracts could be novated and the works continue accordingly. Oops. So some other issues in terms of security arising under both the JCT and the NEC. And security and site materials are always going to be an issue in an insolvency situation. It's also a key issue that I encounter in respect of, as to when title actually passes under the various forms of contract. I think one tip I would give in that sense is it's important to demonstrate the passage of that title by clearly indicating on things like on when interim payments are made, what goods have been paid for, especially if those goods are not incorporated into the works already. It makes it much more difficult to contest that title hasn't passed if there's a paper trail showing that's the case. And whilst I appreciate that creates a bit of an administrative burden, it's certainly a useful process when the claim reaches dispute stage. Vesting certificates also appear to be becoming more and more common certainly in my experience, and I'd fully advocate their use. Again, to avoid any doubt that the title issues may cause. So I'm going to finish with another case from earlier this year that looks at the link between adjudication and insolvency. And I think when Paul introduced me, he mentioned that this is an area that I've got a bit of an interest in, that I suppose that words only a lawyer could get away with saying. I worked with an IP on a matter with a company in administration with millions of pounds worth of monies due a few years ago, and that collection of cases kept me busy for a couple of years. It also coincided with the decisions mentioned on the slide just there in Doyle and Bresco, so I became quite familiar with those judgments at the time. A key issue we faced on that matter was that of not the ability to adjudicate on behalf of an insolvent company, but the ability to actually enforce any positive decisions. The Ball case from earlier this year has now provided some judicial guidance on that, and to an extent answers the question of what you can do as a company in insolvency, or what more to the point, what an IP can do if faced with an adjudication, or if you face with an adjudication by an insolvent company. Now, the approach of the court has always been that there's an unfettered right to adjudicate, which supports the Section 108 of the Construction Act. Whether or not the decision will be enforced, as I just mentioned, is a separate issue, but that was the point that the court looked at in Ball. Ultimately, the Technology Construction Court in Newcastle declined to enforce the decision in favour of the insolvent company in Ball, but that largely went against the grain in terms of enforcement. But it did so on a natural justice point rather than the insolvency point. The court essentially took the view the adjudicator had gone off on a frolic of his own in that matter. However, it was, and crucially for the purposes of today, the court did give some guidance on as to insolvency issues that arose in the matter, and judges often like to do that on important points of law. second element before the judge, which is the important one, was an enforcement point on the basis of the administration. So it was established that the payment was due to Ball following administration, in short. But the issue before the court was the security and how the interim binding nature of adjudication tied in with the employer in that matter's longer term right to come back if he had to challenge that decision. And the question before the court essentially was: is administration equivalent to liquidation, like in the Bresco matter? The court looked at an earlier decision of Straw Realisations and Shaftesbury House, which it considered to be still good law, but clarified it slightly. And what the court said is that it's not inevitable that an application for summary judgment will fail, and that the same that was from Shaftesbury, should I say, and the same applies to administration. Basically, there's no hard and fast rule as to whether an adjudicated decision will be enforced if the claimant company is insolvent. But it did reiterate that the insolvency regime has the edge over the right to payment brought about by the Construction Act. I think the position of that company's administration in administration is now slightly clearer as a result of that judgment. Now, Ball in that matter, via its funder, I think it was Pythagoras involved again, as they often are, offered security. The adequacy of those of that security was considered in Ball, and what the IP and Pythagoras between them offered to do was to ring fence the payment that would be received from the employer, and then the funder would also provide some security to be set aside for the costs of the employer's litigation. The judge looked at the criteria set out in another matter, in another case called Meadowside, and decided that there was no benefit to the employer handing money over if it was essentially going to be ring fenced, and therefore it cast further doubt on whether insolvent companies can actually have these decisions enforced. I think the message to take is that each one will be looked at on its own merits and will be largely dependent on what the IP or the funder is prepared to advance. And it's therefore important to think carefully about what security offers are made if you're working with or for an insolvent company. And hopefully I've not gone on too long there, but that's the end of my talk. So thank you for listening, and I hope you found that interesting, if not too disheartening. I think it's important to say we're not getting away from the current trend of insolvency anytime soon. So hopefully the practical points made today can be of some assistance if you find yourself in that sort of situation. Thank you very much.
Thank you, David. A really good presentation, and it's a difficult one because you've got to squeeze such a lot into a small space of time, yes, particularly around the legal aspects, and it's fluid. You know, you just mentioned there the cases, and it is very fluid in this day and age, and thank you for what you've done there. Okay, without further ado, then I'll pass on to Colin, who's going to provide us his thoughts through the lens of the practitioner. So, Colin, over to you, please.
Good morning, all. Thank you, Paul, and thank you, David. Now, let's see if I can do the screen sharing side of things, which did work earlier. So,
we're seeing that okay now, Colin?
Okay. I just need the presenter view. There we go. I think that's it now. Good morning, all, and thanks, David, for your useful insights. You'll find a lot of what the insolvency practitioner has to do and say is very much linked with the legal side of things. So if I'll run you through a few points on how we see the market, options for recovery, and maybe indicators of what to do when things are going wrong. You've heard some statistics from David and from Paul. We use a data analyst company watch. So there might be slight variances in the figures, but they're not material. And I think overall it shows the same picture of what is happening in this sector. Construction output was 122 billion in 21, which recovered from the depressed levels of 108 billion in 2020. Of course, we had the COVID side of things, which will explain that variance. But it's still over 5% below 2019 pre-pandemic levels. The construction industry accounts for 7% of total UK GDP and employs 2.15 million people, which is the equivalent to about 7% of the workforce. A higher proportion of the workforce is self-employed than in most sectors. And the total assets employed in construction are now over 200 billion with a net worth of 85 billion. So as you see, quite a significant factor in the market. And the sector borrows 29 billion overall. Want to look at managing the risk within the sector. On the slide, the red circle indicates that over a third of companies were in the company watch warning area with a health rating of 25 or less out of a maximum of 100. A company watch operate what we call an age scale, and between 0 and 100. The construction sector sits around about the 40 mark, but as it says, over a third of them have a rating of 25 or less. Statistics for the past 25 years confirm that at least 1 in 4 of these businesses will fail or need major financial restructuring during the next 3 years. As I said, the average age score for the whole sector is only 40 out of 100, which is well below par and lower than shown by the previous data in 2020, where the age score was 42. So there has been a decline in the strength of businesses in the construction sector. The orange circle, that shows 10% of the companies are what we refer to as zombie companies with negative balance sheets where liabilities exceed their assets, at least to a de minimis level of 10 grand. Their combined balance sheet deficit adds up to 3.1 billion. In May 2020, 9% of companies were zombies. So this risk indicator has intensified from the 9% that it was to the current 10%. On this slide, looking at reflection on business size, recent reviews in other sectors have revealed a major discrepancy between larger businesses and their smaller, less well-capitalized brethren. In our analysis, it's segmenting the sector according to total assets per company. The contrast between major players and small businesses is quite stark. The average age score for the construction entities with assets of more than 1 million is 59 out of 100, which is, of course, above the sector average. But for the smaller businesses, the average age score is 31, of course, well below the average. This fragmentation and financial fragility of the sector is also apparent from the starting statistic that almost half of construction companies, that's approximately 113,000, have total assets of less than 50,000. And a quarter of them, some 56,000, have total assets of less than 20,000. Of the small companies with assets of 50,000 or less, a deeply worrying 42% are in the company watch warning area. So there's quite significant financial pressures within the smaller construction companies. With regards to debt levels and repayment issues, at first glance, debt levels are not really an issue. Overall borrowings have risen in the past year by 7%. But gross gearing is only 14% and net gearing is an acceptable 34%. Unfortunately, though, the escalation in borrowings is far greater amongst smaller companies. For those with assets of less than 50,000, debt has risen by 63% in the same period, so quite a significant increase. The The steep rise reflects the heavy use of the bounce back loans, which were introduced by the government in 2020. And out of those loans, just over 260,000 of the loans were made to the construction sector, and that amounted to 7.7 billion. And of those, that 260,000, that represents 17% of all loans made, which is significantly higher than the 7% that the construction sector represents in GDP. So it shows there's quite a need for those loans within this sector. And of course, now we're seeing those haven't been paid back, which is causes that element of further stress. With regards to business failures, as we know, financial stability is a bit of a rare commodity in the construction industry. For many years, in both good and bad economic times, around 20% of all UK insolvencies have been from the construction sector. So it might show stark figures at the minute, but the stats show that this has been pretty consistent over the years of where the construction sector sits within business failures. 1 second. So the continual issues that are faced by the construction sector, and again, some of these were highlighted by David as well, filling workloads, labour shortages and labour rate inflation, possibly some elements of labour unrest. We've seen significant material cost inflation and also supply chain problems with the current environment, with the environment over the last couple of years. Energy costs increasing significantly. The pricing flexibility, it's been a much more difficult market for everyone, which has again led to cash flow problems within the sector. There are options for recovery, as I'm sure many of you are well aware. One thing that we would always say with regards to the insolvency process, it will always be there and there will always be insolvencies, but more so in the construction sector, it has to be seen as very much a last resort. Any insolvency process, no matter how good the insolvency practitioner is, it invariably causes problems within the supply chain. It increases costs and invariably has an adverse effect on the value of any asset that you're trying to dispose of, as it's effectively been sold as a distressed asset. So we would always advise that where possible, deal with the issues outside of an insolvency process, because insolvency, as I say, does cause that distress element. Liquidation would be the more terminal of approaches, and it effectively means a general shutdown of the business and a sale of the assets. When it comes to the construction side and development side, we find that often, although it is subject to a case-by-case analysis, that administration can often give the best outcome, and certainly gives the insolvency practitioner more control over the assets than what it would do in a Law of Property Act receivership. That aside, and to say those aspects are always available in the insolvency practitioner's toolbox, but more consideration should be given to the best option for bringing the company out of the distressed position, be that with a joint venture with another party, an investor, liaising with the lender and negotiating with them as to how maybe you can improve the terms of the borrowing, and anything that can assist with avoiding that insolvency process. I've often said to directors in the past, and I've seen this over the years, that so many scenarios where if we had been involved, or an insolvency practitioner had been involved with the company maybe 3 months before they actually receive that call, it gives you many more options to be able to restructure or save the business. Too many times the insolvency practitioner will get a call on the Wednesday saying that the company can't pay the wages on the Friday. So it makes it a very difficult scenario to try and restructure the business to the maximum of benefit. And as I say, there the options available, although not completely limited to, are the fixed charge receivership, or the receiver would take control of the asset and realize it for the benefit of the creditors and the company if possible. The liquidation, which is terminal, and the administration process, which gives more flexibility in being able to work out the build, complete the projects, and restructure the company as a possible going concern basis. What are the important things to do when you see things going wrong? Stop the works on the site, understand the position and what these issues are, and can they be corrected? Need to understand the position where your supply chain is. Are the payments up to date? And certainly recommended to get a creditor list and validate it direct with subcontractors. Move to direct payments where possible. As the end user, if you're using contractors, one indicator that we've noticed over time is when the head count on the site is diminishing with the contractors, it can often indicate that there's maybe financial problems within their offering. So it's important to keep a close eye on what is going on the day-to-day basis of the projects if you're experiencing that distress. And it's also probably worth considering installing a project manager on the lender's side to assist with communications with the funder and ensuring that they're on board with everything that is going on. Keeping communication channels open is very, very important. And we would always recommend that you speak with your accountant and ensure that you've as many stringent aspects in your management information as you possibly can, and look to balance those outputs and receivables to ensure you can maintain liquidity, particularly when you're hitting the difficult times. Speak to your bank, as I was saying, whoever your lender is, be it PE, be it bank. What they don't like is surprises. If you do liaise with them when you first experience problems, it can often be beneficial, and you'll often find that they will work with you to assist in seeing through a project. Speak with advisors, insolvency practitioners, with your lawyer who specialises in this sector. Obviously, you heard David giving his overview on assistance that can be provided. As I say, the legal side and the insolvency side are very closely linked when it comes to these distress scenarios. But we certainly always recommend that you take advice as soon as you possibly can, or see it might be necessary. I think a lot of people shy away from the insolvency practitioner because they believe it's almost a terminal aspect for the business. But hopefully, and as I've been trying to get across, is the earlier you speak with an insolvency practitioner, the less likely that it will be that you'll require a formal insolvency process, albeit that sometimes it is deemed necessary. Keeping communication with your creditors. It's all good and well being on side with the bank, but what we see all too often is a creditor submitting a statutory demand or a winding up petition, which then causes all kinds of credit issues for the company, including their banking facility. So it's very important to keep as up to date with creditors as you possibly can. We do very much appreciate that often when the company is in financial distress, you're firefighting, constantly trying to probably pay he who shouts loudest. But it is important to have an analysis of your creditors and make sure that you can keep on top of necessary payments. That kind of ties in, but don't ignore the problem. We see it again all too often that the directors of the board, they're continually fighting to keep the business alive, and maybe items slip through the cracks and causes further external problems. Again, this links in with speaking with your advisor, speaking with your lawyer to ensure that you're covering all the bases, and also the directors are acting within their fiduciary duties. And don't stop. It's the term I would use is we often find that people, when it becomes too much, they put their head in the sand, and unfortunately that doesn't help anyone. You do need that line of communication, and you do need to be speaking with everyone within the structure of the business, be it the bank, the suppliers, the creditors, etc. So how to deal with people going bust in your supply chain. This, again, is a common factor that we see. And what is very important here is to, once you see problems with the supply chain, is secure a fresh and up-to-date scope of the works that need to be done to practical completion. And then re-tender with new contractors quickly and openly, explain to them what the position is and the requirements are going forward. Again, this is where a project manager, lender side, could be very useful to help oversee the position and help with adjusting budgets and the program to PC. And also important to give yourself a contingency plan within that as well. As you know, we all know about the struggles of securing supply or securing that new contractor when a project goes wrong or the contractor finds himself in an insolvent position. There's also the issue of, and David touched on it earlier, with performance bonds. So if it does become an issue with the contractor, that is an area that you should explore immediately and address if you can. The supply chain, again, as we all know, is definitely easing on what it was a couple of years ago. But we should, where it's possible, look at the likes of debt insurance, which in this sector, unfortunately, over the years has become increasingly more expensive, but it's often available there if necessary. Managing the creditor terms and debt collection, just keeping on top of the debts that are outstanding and payments that need to be made, particularly the necessary payments. You don't want that stat demand or winding up petition landing on your door. Again, with it, be mindful of alternative suppliers. If you're seeing issues with your current providers, it's always good to have that backup of parties that you can turn to keep the contract going. And manage the expectations. This is very much pointed towards the funder and even down to the taxman as well. Again, can't emphasize enough that it's so important to make your funder or any creditors aware of what the position is and problems that you're experiencing. More times than enough, it can be resolved, again, without the need for that insolvency practitioner to be formally appointed. I'm sure from myself and David, it will throw up many more questions, which there's a question and answer at the end of the period. So thank you for your time, for listening to me, and I'll hand you back to Paul.
Thank you, Colin. Some big takeaways there. First one for me was the statistics that you gave, some alarming ones there around the number of zombie companies that potentially are trading and we don't know who we're trading with. And also the managing the risk. I use a key one, which is always managing expectations, and you've mentioned that at the end there. I think for yourself, as you've suggested, is timing is key. And the amount of times that we've been involved with projects where if it had got us in earlier, slightly earlier, then we could have assisted them as well. So absolutely,
very much
is key in this. So thank you for that. Okay, so I'll now hand over to Bill, who will talk about the quantum aspects of insolvency. So Bill, over to you, please. Thank you.
Okay, thank you, Paul. Just sharing my screen. Should be there. So good morning, everybody. Thank you for the introduction earlier, Paul. Just to remind people, my name is Bill Bordill. I'm a director of Decipher, and I'm a chartered QS and now practice largely as an adjudicator and a quantum expert. So just moving on to my first slide, quantum matters. Now, to some people that will be a heading, to some people that will just be a statement. I guess it depends on your view of the role of the QS in a construction project. But trust me, when it comes to getting paid in a claim, and we're talking about claims for loss and expense arising from insolvency, then quantum really does matter. I'm going to talk through the consequences of insolvency in the context of construction projects and try and provide some tips and help, i.e. some early warnings for what might be able to be done to help the situation. Now, there is a little overlap between what's been said previously by David and Colin, so I'll try and cut that out. And also I notice we're a little bit behind time, so I'll tweak things as I go. So please bear with me if there's a few disjoints here and there. Now, one thing to bear in mind is that insolvency can happen to any party to a construction contract, whether that's the end user client, the contractor, the consultant, the subcontractor, suppliers, subconsultants, subcontractors, virtually any party, upstream and downstream. So I'm anticipating there's a mixed bag of listeners to this webinar. So please listen to this in the context of your particular situation. So if I talk about an insolvent contractor, I could equally be talking about an insolvent subcontractor, supplier, or employer. So in summary, I'm going to set the scene by discussing claims, remind you what insolvency is, show you the various definitions for insolvency in the contracts, and then provide some proactive and reactive steps to help you, hopefully. Okay, so the quantification of claims. The claims that we're talking about really are loss and expense arising from insolvency. I've been given this as a topic for this presentation, but to be fair, there is no difference between the formulation of a claim in insolvency than there is in any other event that would give rise to a loss and expense claim. So that's been well covered in various webinars over, particularly the COVID period. So I don't propose to remind everybody exactly of what's been said there, but if anyone is particularly interested in the key elements and how to put a claim together, then point 5 is relevant. Would urge you to look at the Decipher website, where I've recorded a webinar on the 4 corners of the claim. I think Paul has also got an article by the same title. And this is where we talk through the 4 corners being cause, effect, entitlement, and substantiation. So all of the points above are all relevant, but the 2 points I want to talk about here are 6 and 7, being the difference between the JCT and the NEC. Now, the JCT, as we know, takes a retrospective position, and the NEC generally takes a prospective position. Now, the difference here in insolvency is, if you had an insolvent contractor or party early on in a project, under a JCT contract, you wouldn't be ascertaining the costs for loss and expense until after practical completion, which can cause some quite surprising issues. However, on the NEC, you would be forecasting the costs at the time of the event, so therefore not relying on actual costs. One to bear in mind, and one we'll perhaps come back to. So on to my next slide. What is insolvency? Well, David and Colin have clearly explained that, but just by way of a reminder, it means 2 things to me. Basically, it's the inability of a company to pay its debts, and it's a reason for termination. So let me just talk about those 2. The inability of the company to pay its debts. Well, who says that the company can't pay its debts? Well, there is an Insolvency Act which gives a definition, but there is also definitions in the contracts, most standard form contracts. And if we look at the JCT and the NEC particularly, on the next slides, I will explain the differences in the definitions. We talk about it's a reason for termination because that is one of the clauses in the standard forms of contract. I just want to clarify some wording here because old school language was that you determined the contract and terminated the employment of the contractor, which is fine, but language has softened a little bit in recent times, and it now appears that determination and termination are words that are interchangeable. So don't get hung up on a pedantic point here. When somebody talks about terminating the contract, they don't actually mean terminating the contract, which would end all obligations and rights within the contract. What they mean is termination of the employment of one of the parties to the contract. Now, there is a huge word of warning here, and that is it is possible to terminate prematurely, and we quite often see that. And I would advise anybody who's thinking of termination, so that they've done their due diligence, they've taken the early steps that Colin was talking about, and they want to terminate the contract of maybe the contractor, please take some legal advice and do it at the right time. If you do it prematurely, you could face a claim, a rightful claim for repudiatory breach of contract, which would mean you would have a loss of profits and overheads claim coming back your way, in probably addition to other costs as well. So it's important to act early, but not too early, and I will come back on that point. So looking at the definitions, I don't think there's a need to go through in great detail here. If people want to know that, then they can have a copy of the slides. But the Insolvency Act sets out what will apply if this isn't covered by one of the standard forms of contract. On the next slide, I've got the JCT suite of contracts, which brings some clarity to when an employer of a contractor may be terminated. And if I look at the NEC suite, I see that that's broadly similar to the JCT and also provides some clarity. So it becomes easier to understand when a contractor may be going into difficulties. So what is the insolvency problem? Basically, it's a lack of cash with one party unable to pay its short-term debts. They may be very profitable, which your research may have revealed when you were selecting that contractor. And people do tend to focus on profits, they don't focus on liquidity, but it's liquidity that really matters. But the big consequence of insolvency is if there is an insolvent party, the project's going to get disrupted and probably delayed. Even if it's a subcontractor, there is a main contractor in between the subcontractor and the employer, but the net effect on the project is likely to be delays. So what causes that? Well, global inflation, higher interest rates, talk of domestic recession. I've thrown the last one in because on a lighter note, we often notice the tabloid papers when they're short of news, they'll suddenly say there's a bread shortage, or more recently there was apparently a tomato shortage. And lo and behold, people go and stockpile these items, and then there is a bread or a tomato shortage. We need to be very careful that we don't overtalk the issues that we're facing currently, because we have, in my experience, talked ourselves into recession in the past, and we are in grave danger of doing that again. So we mustn't do that. But what is the problem of global inflation and higher interest rates and all of those things? Well, it's the problem of a disconnect between, or a disharmony between cost and value. So where the costs are rising, but the value to the contractor is static, i.e. he's on a fixed price, but he's paid more and more and more, there comes a point when he can't meet his short-term debts, and insolvency is just a natural consequence. So it's clearly the major issue with insolvency is a disharmony between cost and value. Rising costs squeeze on margins. I've put that because when there are tight margins, there's no fat in the rates. Therefore, it's very, very important, especially if insolvency is anticipated, to make sure that valuations by the QSs are undertaken very accurately and regular payments are put forward to the supply chain. It may even be the right time to make a pragmatic view and decide, are you going to pay early? I wouldn't advocate paying more, but you may want to change your payment terms to ease the burden on the supply chain. There's nothing to be gained from improving your cash flow if it proves to be fatal to one of your suppliers, because ultimately the project will be disrupted. There's a general view in the industry that the supply chain is at a higher risk of insolvency now than since the financial crisis of 2008. That's not my view, that's a wider view. I'm not saying I disagree with it, but it's a wider view in the industry. And we're all at risk, whether we're as employers, contractors, subcontractors, suppliers, consultants, or sub-parties, as I explained. We're all exposed to the risk of insolvency. And that's exactly what insolvency is. It is a risk. And it's a risk to be managed in exactly the same way as every other risk through a construction project. So it's a question of understanding what that risk is and assessing what the impact of that might be upon a project if insolvency became a reality. So let me look at some proactive steps. So these are the steps that might be able to be taken prior to getting into contract with one of the parties. I've talked about, I've got down there as a heading, due diligence. Well, by due diligence, I mean investigate the financial strength of a party, undertake a D&B report. Now, that's become a generic term for a financial check, but there are other brands available, obviously. Critics of this sort of approach would say that the information is largely historical. It usually relates to the last financial year and years before that, but it can prompt questions arising from trends. So they are still worth looking at. But what about asking for current management account information? Critics would say it's not verified, it's not auditable or audited, but it is at least current. And I'm thinking there are things like a profit and loss statement, a cash flow statement. It really is important to establish the liquidity of the company, its ability to pay its short-term debts. This sort of investigation will also reveal the true ownership arrangements of the company. Are the parent companies involved, or are the risky subsidiaries involved? What I'm suggesting here is that you should make this a regular part of your tender adjudication process. It isn't all about lowest price or closest to meeting the specification. It's also about the liquidity, the ability of the company to meet its short-term debts and avoid the risk of insolvency. I've written down careful drafting of the contract, and I'm thinking here of various items that I think David touched on some of these as well, but I'm thinking here about drafting in a requirement to provide various forms of security, whether that be a parent company guarantee or performance bonds, writing in some clauses that would establish rights to ownership of materials. That's always a thorny subject when a contractor goes bust and or becomes insolvent. You know, the money's been included in the monthly progress payment, but who actually owns the materials? And there's a distinction between materials incorporated into the land, that's materials actually introduced into and built into the works, or materials just sat on the site. And the rules are dictated by the Sale of Goods Act for materials supplied by a supplier, or the Supply of Goods and Services Act for materials supplied as part of the subcontractor's works. But it might be better to take the debate away from that and have terms drafted in such a way that the ownership of materials is very clear. I think it was David who mentioned vesting certificates. That's well understood for materials off-site, but I would advocate also vesting certificates for materials on-site as part of a way of clarifying who actually owns the materials at any one point in time. Other clauses that you might want to write in would be the right to omit any portion of the works, or step-in rights with key suppliers and subcontractors, a discretionary right for direct payment to subcontractors. I think that was mentioned by Colin, and also a requirement to maybe see evidence of payment to subcontractors, because what you're really interested in is making sure that your payments are flowing down the supply chain, and there is little point in you paying the main contractor if he's not paying the subcontractors. Eventually, you could still have a problem on your project. We mentioned risk analysis. And with that, I'm talking about the assessment of the likelihood of insolvency and the severity of the impact of that upon your project. And under project control, I'm thinking of making reasonable and regular payments. It's all about keeping the cash flowing down through to the supply chain. That might mean that you want to go to fortnightly payments. We've seen that, where more pragmatic clients just want to keep the whole process going. They realise that it's more costly to deal with an insolvent contractor than it is to actually change the terms and work towards avoiding any insolvency. It's really important to keep accurate records. Max Abrahamson's words, records were on one of my early slides. It's because at some point you will be required to establish the true value of the works. And one thing I would suggest is try and ensure soonest installation of materials. This is getting back to the issue of who owns the materials. Once the materials are incorporated into the works, it's called incorporated into the land legally, the situation becomes much clearer. So you really want the soonest installation. You're not looking for materials that are long-term stored on site. And prepare for termination. Have a backup plan for the demise of key subcontractors. So those are my proactive steps, what you might do prior to any insolvency and trying to avoid insolvency. But what can you do should you be faced with insolvency? Well, avoid the knowledge loss. Certain key suppliers or subcontractors may have staff who have all sorts of knowledge in their minds, and you know, it's not always all written down, it's not always readily available. Try and avoid the longer term learning curve with new people. So you can mitigate the impact of costs and delays by recruiting key staff from insolvent companies. Line up a replacement contractor to mitigate the impact of the insolvent party. I mentioned earlier about having a backup plan or a disaster recovery plan, but have these companies waiting in the wings. That's not usually the case, but why not? You know, it's a major part of trying to deal with an insolvent company. Perhaps the first thing that you might want to do is secure the site. And this again comes back to the ownership of materials, which is a big issue. You can tell because it's been mentioned several times now. But site security is something that tends to not get dealt with as quickly as it perhaps should. So the first step would be to immediately secure the site and prevent materials being removed from site until the ownership has been decided and agreed. Another item would be protection. We've talked about performance bonds, parent company guarantees. Just to elaborate on something David said earlier, I think it's possible to have bonds which expressly state they would be triggered in the event of insolvency. But I'm also been made aware that some bonds have been triggered by insolvency because there's been a breach as the insolvent contractor hasn't paid third parties. But that's an issue for the lawyers and the insurance companies to sort out. And finally, I've put understand your contractual position. Understand what should be paid and what should not be paid, and understand the differences between the JCT and the NEC, which I touched upon earlier. and make sure that you keep payment notices and pay less notices aligned so that you don't end up paying for work that you yourself are not getting paid for. So finally, my top tips and takeaways. First one is clearly keep your eyes and ears open, be prepared, do your homework, do your due diligence, understand what you're getting into, and it's all about liquidity. Have a written contract with expressly stated protection mechanisms. These could be the bonds, these could be the various clauses which I talked through. Administer the contract properly. Now that's advice for every single project, regardless of insolvency, and keep up to date with site progress. Maintain proper records. That will be your evidence if you do end up making a loss and expense claim. And act quickly, but don't jump the gun. This is in connection with don't terminate somebody's contract too early. Do please take advice from professionals. This isn't the time to cut corners. Now, one final thing to say is a word of caution. On the day of its liquidation, Carillion is reported to have held 800 million to £1 billion in retention, the majority of which did not find its way back into the supply chain. But quite a sobering final thought. Sorry for that. It's a serious subject. Thank you.
Thanks, Bill, for your highlights there on the quantum aspects. I would tend to agree that do the fact finding, most definitely at the beginning of a project, understand who you're contracting with, get valuations right in terms of the valuation of works on a monthly basis. And don't cut corners. I think if you're going to cut corners, it's going to make Colin's job and David's job a lot more difficult when, unfortunately, you're dealing with a termination or solvency matter. Okay, so in terms of questions, I'm just looking at the Q&A. There's just one, just actually a thanks, actually. Thank you from John. So I've got, until we get some questions coming in, I've got a couple of observations that I'd just like to bring to the panel's attention if possible. So we've spoken at length about what precautionary actions that the employer and project owner could take if they become aware that the contractor is to become insolvent. And I've seen it that some solutions might be to appoint a management board that appoints those subcontractors directly or has direct contracts with the project owner. So from a legal perspective, from an IP perspective, Colin, are there any complications with this approach and any tips that you might wish to give our listeners, please, whether to do it or not do it? So, David, I'll hand over to you first, please.
Thanks, Paul. Well, firstly, yes, in theory, that idea works quite nicely in terms of from a continuity perspective. I suppose the potential complications that arise there are, firstly, if the subbies are due existing money that they haven't been paid, then there may be a reluctance on their part to get back on site. So, as the management company or the paying party in that situation, there might be a necessity to pay them what they're already due, which there's a potential there for that to amount to a duplication in payments if you've already been paid the insolvent party for those services. I suppose if it's the main contractor that's become insolvent in that situation, then you need to have a think about who's going to take on the principal contractor role as well from a legal perspective, because that will default to the client. I mean, I'm speaking very broadly here, because obviously it's a non-specific question. Payment terms with those subbies as well, whether they have agreed specific payment terms with the insolvent company as well, and generally as well, if there's an issue with, or if there has been an issue with the relationship between those two parties. I mean, it often turns sour when companies do become insolvent, so that gap may need bridging as well, I think. So yes, whilst it's not out of the question, it certainly wouldn't be one that would be without complication.
Sure. Okay. Thanks, David. Colin, anything to add to that, please?
Well, I think David covered all the aspects of it. A couple of things that Bill mentioned in his presentation, with regards looking at those skill sets that may be available to retain the knowledge about the project that has been ongoing. As again, Bill emphasised records, but it's not always the way, and a lot of the knowledge is retained with the individual. So, in exploring the potential to keep those who may be useful to completing the project, and very much speaking with your funders.
Okay, thank you. Just got a couple of questions coming through on the Q&A now then. So for John again, John Mazzari. So his reference here is more of an observation. It says the takeaway I get is it's a lot better to carry out the diligence and avoid the issues rather than to try and sort out the mess caused by insolvency. I think we'd all agree with that, but unfortunately that would leave you out of a job, Colin, potentially.
It would, and quite often find myself maybe talking myself out of work, but it's the best approach. Insolvency has to be the last resort in any aspect. There will always be insolvencies. It will always be work for the insolvency practitioner, but engagement early on and exploring those potentials in conjunction with the likes of David, with the likes of Bill, to avoid it. As I said earlier on, it introduces extra layers of cost. It depresses the value of the asset. Invariably, with a fair wind, you can get around that, but invariably, it has a financial adverse effect on the realizations.
I think if your contractors are doing their due diligence properly, and employers, they might employ someone like Colin's services early on to help with that due diligence, because we're talking about liquidity, and this is not really part of most people's due diligence. They tend to focus on technical matters, competencies, resources, and strangely profits and turnover. Very few actually look at liquidity and ability to meet short-term debt. So it may be that Colin's got some good ideas related to specific situations. So I would encourage companies to speak to an insolvency practitioner at a very, very early stage to find out how to avoid it.
Yeah, I'll just add to that. We were involved with a project at Decipher, which was with Carillion, against the Carillion a number of years ago, just before their demise. And our client at the time was asked to get their plant to site. And they pretty much got half of their plant to the project to start doing the work. And then, unfortunately, a few days later, the Carillion went into insolvency, and our client's plant was locked up on the site, and they couldn't get it back. And then, unfortunately, that left our client unable to trade because they had nothing to trade with their plant being tied up. So, I think that due diligence piece and knowing who you're contracting with, and it really is key to all of this. Got a question here from Mr. Varney. Hi, Rob, good to see you. Thanks for joining us today. Rob asked the question, does the panel think that a lot of the insolvencies of smaller construction companies are a symptom of how the construction industry operates? Question mark. So who would like to take that? Colin, do you have a view on that at all?
I think there must be an element of that with the payment terms that are undertaken, and I think, like many sectors, it tends to be the bigger boys who can crack the whip that bit more. This is where it comes down to managing your finances as tightly as possible, and not letting those debts drift for 45, 60 days. And maintaining good payments with your suppliers. And again, as Bill highlighted earlier, quite often it might work help on a cash flow basis, and certainly a relationship basis, with changing those terms to more beneficial to the supplier, in support of them. But definitely micromanaging those payments is very important.
Yeah, an observation that I've seen is, obviously during the COVID times, there was a lot more of just getting on with the jobs together and collaborating around getting the job over the line, and there was the uncertainty around COVID. But I think people have now reverted back to the old type of fighting for their money And my advice to clients would be, don't forget you've got a contract there to use. It's the level playing field, so don't be afraid of using it, but make sure you understand exactly how you're going to use it, and take the advice from the likes of the lawyers and Colin on the call today. Anything to add to that, Bill?
Yeah, I was more or less the same point, to be honest, and that is the contracts do provide protection if you're not being paid properly and fairly and on time. So take advice. That doesn't mean to say you've got to fall out with your client and sever relationships, but take advice first. Early advice is, I guess, the right advice for all these situations.
Sure. Okay. David, anything to add on that legal aspect?
Yeah, I think so. Yeah, I think. Well, first, I agree with everything that you said, Paul, Colin, and Bill on that point. I think there's still a tendency with the smaller construction firms to be relatively unsophisticated when it comes to contracts. So I'm often approached by smaller subbies usually, with basically no written contractual terms in place at all, or they might just be functioning off the back of an order. And the issue is a lot of the time they don't understand fully what. I was having a conversation recently with a relatively small subcontractor who wasn't aware of the existence of the Construction Act and the payment provisions that deploys. Likewise, I think retention issues are key as well, and early payment discounts as well. That some of the bigger boys, as Colin mentioned, some of those impose. So I don't think it's the payment provisions or the dispute resolution provisions are particularly geared up towards the smaller companies. And I know we gave lots of stats at the start of the call. Sorry, the webinar. My suspicion is that lots of those insolvencies are largely the smaller construction firms that are struggling, and that's largely because they can't always afford to go through an adjudication process or to seek the advice that they need, or to incur the cost of a contract review at the start of the matter, and they're happy as a result, or content, should I say, to take the risks on that I mentioned in my talk.
Okay, thank you, David. One matter that comes up regularly is around warranties, and we've experienced a number of specialist contractors, specialist subcontractors that have folded, and then the incumbent replacement contractor has tried to pick up the remaining work to complete. And there's always a question around the warranty: who's going to warrant the work that's already there, and where does that sit in the grand scheme of things with the employer? David, do you have any comments on that, just to give the audience, please?
Yes, of course. Well, I mean, firstly, my experience of that is, and I think Bill may have touched upon this, or it was perhaps Colin, in fact, in their talk, in that if you have an insolvency situation, then it's important to it was Colin, in fact, to redefine scope at that point. And I think that's an important reactionary measure to be taken by the project manager or by whoever steps in at that point. I think what I would say is, as well, to add to that, is that there has to be not so much a desire, but a willingness to pay a premium on that. Because if a contractor picks up somebody else's work, then firstly they've got they know that the non-insolvent party is in a fairly desperate position, and they're going to charge accordingly as a result, not least because they are being expected to pick up somebody else's work and to warrant the same, if they're able to do that in the first place, that is.
Okay, thank you, David. Conscious that we are coming up to the hour and a half at the end of this for the session. There are no other questions in the chat that I can see. So I would like to obviously bring the session to an end just by thanking you all for attending today on the webinar, and to thank the speakers, for David, Colin and Bill, for giving up their time and for presenting the presentations themselves. They do take a lot of time to create, so we do appreciate you giving your time up today and for attending this session. I would also like to thank Caris and Annie and Stuart from Lineslave for helping us to facilitate. And as we said before, this will be recorded, or has been recorded, will be on our website and available for those that haven't been able to attend today in person. So without further ado, I wish you all a pleasant day and keep safe, and we'll see you again soon. Thank you very much indeed. Bye-bye.
Thanks, Paul. Thank you. Bye.